Hey, Brian Parker here with a quick pro tip. You ever heard of the Impermissible Purpose Doctrine? Let me explain. Let's put it up. Shazam. 15 USC 1681 BF. A person shall not use or obtain a consumer report for any purposes unless the consumer report is obtained for the purpose for which the consumer report is authorized to be furnished under this section. What that means is, in a sense, there are 6 reasons that someone can look at your credit report, but only 6. Let me put those up there. Shazam. In response to a court order, that's usually through a divorce agreement or a custody issue or some business merging or something like that where someone doesn't trust another person. A credit transaction. Hey, I'd like some credit. Employment purposes, just about every job now you apply for requires you fill out an FCRA application saying we can look at your credit, and especially if you need a security clearance. For insurance, that's all based on your credit score these days. A legitimate business need, that is what it is. And for an account review or collection, what that means is you've authorized somebody to check your credit report regularly. So if they see you making a lot of purchases, maybe they give you less credit than the balance they originally gave you because they figure you're becoming more of a risk. So they're just protecting their interest in you. Here's what to do if you find something on your credit report. So an impermissible purpose doctrine says you look at your credit report and there's something on there from a company that's in the hard inquiry section usually that you had nothing to do with, didn't authorize to look, and that hard inquiry is going to be in your credit report and pulling your scores down for 2 years. So you can file a lawsuit. And the reason I say that under the FCRA is because most FCRA cases are called furnisher cases, where you must send them a letter saying, I dispute I owe this the way you've listed the trade line, that's the marking on your credit, or I dispute the way you've pulled my credit, fix this, delete it, or give me reason not to sue you. But you've got to give them 30 days bite of the apple to fix. That's the rule under most FCRA cases. Under the Impermissible Purpose Doctrine, you can go full in, do a lawsuit the minute someone's on your credit report. And it's usually the damages is pulling your score down and they're breaching your privacy. But I don't do that. This is what I want you to do. Shazam. First, request a copy of your entire report. You want to see where that's been pulled. Is it just TransUnion? Is it Experian and Equifax? Or is it all 3? So go to annualcreditreport.com, and that is a free, full detailed credit report everybody in America is entitled to once a year. And you'll see all the things, all the good and if there's bad on there. And then just circle what you know not to be true. You take that page and you attach that to one of my impermissible doctrine letters. You aren't required to send these letters to have a lawsuit. This is one few exceptions under the FCRA, but you do. You want to show the court in good faith. I tried to work this out. I said, could you tell me why you're on my credit report? What debt did I authorize that you review? I don't know if I've ever seen anybody respond to those letters, but the response that you want is from the judge saying, okay, this guy didn't just file a lawsuit, he asked them to fix or to explain, and that's Exhibit 1 for you. Exhibit 2 would be explaining any damages to your FICO score or how your interest rates went up, or one of your legitimate creditors looked to see that you've got other credit on there and denied you further credit because of it. So those are all damages. So if it's a soft or hard inquiry, generally a hard inquiry, you've got a case under 1681 BF because they have no permissible purpose to touch your credit. Or as they say in the business, pull your credit. So you can add, I just did the video with the 4 E's and the F. You can add 1692 under the FDCPA E8. That's exactly the FCRA, but in a FDCPA context against debt collectors. And of course, the 1692F, as I talked about, those are both accompaniments to your 1681 BF in your lawsuit or defense or your counterclaim. It's very powerful stuff. And under 1681N, you're entitled in some cases to punitive and actual damages if you can show a purposefulness and a willfulness and an ignorance, or ignoring your good faith requests to explain, like sending my impermissible purpose letter, which will be on www.killdebt.com. That's where everything is. All the forms you need, all the dispute letters you need, all the validation letters you need, all the defense of everybody. Just go to the search bar and type in what your request is. So I hope you enjoyed my quick pro tip analysis of the Impermissible Purpose Doctrine explained. Thank you.